Hi, everyone. Welcome to Turning a Moment into a Movement. And I am J Love. I'm your host, and I also represent the Justice for Gerard movement. Um, Gerard's my son who was wrongfully convicted of a crime he didn't do, innocent, and he went to prison for that crime. And so, because of that journey with him and meeting so many others who were on that journey, um, of freedom from wrongful convictions, I created this platform to come here on Fridays to educate, to motivate, and inspire, but most of all to just to educate our community about wrongful convictions. Our mission is to bring awareness to the wrongful conviction of Gerard and all others who are wrongly convicted, over sentenced, mentally ill, medically frail in our community, to inspire, organize, and educate all communities about the need to disrupt systems, policies, and patterns of the criminal legal systems that lead to wrongful convictions. And so that's why we're here. We've been on break a little bit. Gerard's birthday was recently, it was like the week before the last time we were here. So we took some time off, and I just had to take some time to just reflect and do some healing and some self love for myself, and just hang out with my family, just to remember Gerard, um, and to honor him, his legacy. And the reason why we're doing this, that we're coming here, there's so much going on in the world. Every day we hear so much, but we have to still stay connected to our communities and what's going on within our communities and our families. So that's why we're here. Again, thank you for joining us. And I want to say, and I don't get to do this all the time, but for all everyone that's on all the platforms that we're on, Facebook, YouTube, um, Instagram, Twitter, I just want to say hello. Thank you for watching and supporting. And those who might watch and listen later on podcast, Apple Podcasts, or Google Chrome, iHeart Radio podcasts. Just thank you guys for supporting us. We couldn't do this without you, and we asking you guys to please share these videos, share these on your platforms, because this is how we get this information out to others. We always have people reaching out to us, because somebody shared it and they heard it, or they saw it on YouTube. So continue to share this info. And if you want to join us on this platform, or if you have some questions or you want to connect to some of our guests or the people who are on this platform, you can email us at turning a moment into a movement at gmail.com. Again, you can email us at turning a moment into a movement at gmail.com. Leave us a message. We will get back to you. All right, we will. So next, I'm going to bring on Reverend Tia. Hi, Reverend Tia.
Hey there, how are
How
you? I almost forgot where the little icon was. I am
I'm great.
doing wonderful, Jay. Thank you so much. Thank you for the work that you do, and just thanking God for your strength and your vulnerability too, in sharing Gerard with us, sharing the movement with us for those who have joined in and have become more aware of how we need to stand together, work together, and that it's going to take more of that today, of
Yeah.
standing with each other, being, team players, being a part of the community. And I'm just excited to be here this evening, coming from the choice zone where your choice matters, helping people get in their zone, whether it's no matter what your zone is now, get there, get to your purpose, your dreams, your passion. Um, And so, we stand with you. I'm glad to walk with you on so many platforms, not just here, but with Michigan Coalition for Human Rights, and definitely with Transforming Love Community. No matter where I go, I have to ask myself, am I in a community that is like and reflects my ethics, the love that I have, everything, my everything? Is it me? And I think when we come here, a lot of times as we educate, we need to ask ourselves, is this you? Is how you're acting you? Is how you are relating to others you? Is that really who you are? Shout out to my G100 women connecting all over the world. Yeah. So,
Yeah.
is that you? That's me. And my thing is, Jay, I want everybody to be the ultimate of whoever God has called them to be. And I believe that even in this walk, as no matter what I'm doing, my faith is stronger because I'm seeing synchronistic patterns of people coming together and change actually happening.
Right.
There's a purpose and there's a reason for what we do. And I'm so glad you thanked everybody in the beginning, those who have supported us along the way. Thank you so much. Just excited to get with Miss Diane tonight and see what's
Yeah.
happening, how we can stand.
Right. I want to say, about Miss Diane. She is really a trooper. She's a legend. I mean, she's out here really doing this work, her and her husband, and this newspaper. And so we want you guys to support this paper, to keep
Yeah.
this online information going
Mhm.
on. It has helped so many. We have seen, because of her work, so many coming home from wrongful convictions, from her
Mhm.
can't even say the word, advocacy work.
Mhm.
So you guys, please, 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 please go before we even get started, just in case we forget, to
Yeah.
donate. Go to the Voice of Detroit, www.voiceofdetroit, and it's if you read one of the stories or whatever, there is a link where you can go in and you could donate to keep this newspaper going, this online paper. Um, so thank you guys in advance for that.
Mhm.
And now we're going to move forward. Attorney Mack is going to be
Mhm.
in later. He has a monthly meeting that he has to attend. And so we're going to move forward with Miss Diane. We're going to bring her in because this story is a very, Ricky, he has been in prison for over almost 50 years now.
Mhm.
So we really need to pay attention to this story.
Mhm.
Greetings, Miss Diane.
Hi, everybody.
How
Trishay and Bill. How you doing?
Oh, I'm great. How about yourself?
Okay.
So this story, I've been reading it. It's a lot, Miss Diane.
Mhm.
Yes.
It's a lot. 50 years, almost 50 years wrongfully convicted, um, for a crime he didn't do. It's almost insane. But first, before we get into it, just introduce yourself right quick, and then we're gonna bring in Travis.
Okay.
Mhm.
I'm Diane Bukowski. I'm the editor of Voice of Detroit and been covering Ricky's case for several years now.
Greetings, Miss Diane, and we're gonna bring in Travis. Hi, Travis.
How you doing?
All right, you.
I'm okay.
Thank you for joining us this evening.
There you go.
So let's you can give us some background on this story, Miss Diane.
Okay, well, Ricky has been locked up since 1976 and on the murder of a white car dealer on the east side near where he lived. and a robbery murder that he did not commit. And he has witnesses now to say that. But the main thing right now, he's been appealing, and Travis was instrumental in drafting the motions. He filed motions pro se back in 2022, asking for a new trial and an evidentiary hearing based on several factors. One of the chief, or two of the chief factors, are the officers who concocted his conviction, and that is Leo Haidys, a white officer who's now deceased, and James Harris, both from the Detroit Police Department. I'll start with talking about James Harris, because right now that's a key issue. James Harris was with stress. He was one of the few black cops on the unit that people remember, Stop the Robberies, Enjoy Safe Streets, that ended up with white cops, mostly white cops, killing young black, well, people of all ages, but mostly out of 24 people that they killed, 24 men and women, 22 were black. And there was a huge uproar over that in the community. A lot of people probably remember in 1970, in the early 1970s, before Mayor Coleman Young was elected, there was a huge movement against stress. And at the trial, Ricky went to trial in 1976. Now, at the time, he did not know. And the prosecution should have informed him that James Harris was charged in the Rochester Street Massacre in 1972, in which, and a lot of people remember that actually, that's involving deputy sheriffs, black deputy sheriffs that were killed by a unit from stress that included James Harris and two other black stress members, along with two white officers that went and aided them. They stormed into a party that was, well, it was a party, it was a get-together at an apartment of black deputy sheriffs that were playing cards. And they used a pretext that they saw one of the sheriffs going into the complex with his gun. But sheriffs were required to carry guns at all times. Now, they stormed into there and ended up killing Henry Henderson. He was one of the deputies, one of the black deputies, and seriously wounding another one, James Jenkins, who was injured, disabled for life as a result. There was a huge controversy in the community about it because of its involvement with stress. And the sheriff's office at the time disputed any involvement of their people. Their people did not, the sheriffs did not fire their guns. The people that fired their guns, they went in with their guns blazing. And James Harris and the two other stress members and two white cops. The white cop was the one that killed Henry Henderson. And they went in and had a huge shoot. Well, they called it a shootout, but the people that initiated the shootout were James Harris and his squad. So, and he was tried. James Harris was tried along with others that were involved in that, was charged in the Wayne County prosecutor, in the prosecutor's office with, hold on a minute, with attempted murder and a variety of other charges that were brought against the other people. Now, they didn't charge, Cahalan back then didn't charge the white officer. He was the one that actually shot Henry Henderson 6 times, causing his death. But he charged the 3 black officers, and eventually they had a trial in Wayne County where Cahalan wasn't really pushing for convictions. And as a result, the jury ended up deciding acquitting the cops. Now, Travis can talk later about why that doesn't make a difference, the fact that they got acquitted, in just a little bit after I get through with, I'll try and wrap up with the explanation about this now, because the judge has just denied the motion back in February, Ricky's motions. Under Brady, he is contending that under Brady versus Maryland, which is a Supreme Court decision that says the prosecutor is supposed to reveal all evidence on the side of the defendant, exculpatory evidence. Ricky was never told about the situation with James Harris. It's likely, I'm sure the prosecutor, by the way, the assistant prosecutor was Timothy Kenny, who later on became the chief judge in Wayne County Circuit Court. And it was his obligation as the prosecutor to inform Ricky, the defendant, and the jury at trial of any irregularities in the backgrounds of the officers that testified. And I really should turn it over to Travis right now, because he can explain that better than I can.
Okay.
Yeah, let me see. Travis, do you want to explain all that?
Could you hear me?
Oh yeah, we can hear you good.
Well, under Brady, they didn't have to tell the jury about it. They were supposed to inform the defense, so the defense could know what they were going to do in regards to this witness taking the stand. Okay. Every other prisoner or defendant that get arrested and go to trial, they can cross-examine witnesses. The police is no different. All right. Now, since RIMMER did not know about Harris' misconduct and being charged with attempt murder, etc. Before they were charged, well, before they got found not guilty, they had a disciplinary hearing, and they were found guilty at the police disciplinary hearing and suspended. They was only reinstated after the jury found them not guilty. But that's another part of the story. Now, the other officer is Leo Haidys, a white officer, when I think 70 or 1969 won. It was a thing they called the Veteran Memorial Incident downtown, where about 12 white police officer wives was giving them a little party in the Veteran Memorial. And at the same time, some black church-going kids was being chaperoned for a little party down there. One of the bathrooms was broke, so the kids and the officers ended up having to use the same bathroom. Next thing you know, is the little black kids came running up out of the building, being chased by about 12 white off-duty officers with their pistols drawn, using racial slurs and, things like that. Okay, the officers was arrested. It was about 9 of them. They were suspended after their misconduct hearing. And then 2 of them was charged that I know of, Haidys and another one. They decided that Detroit was too black for them, I guess, and they requested a change of venue to Ingham County, which was granted, and the trial was held in the Ku Klux Klan stronghold of Mason, Michigan. And the jury found them not guilty, even though the kids testified. The jury found them not guilty, and they went back on the police force. Now, that is the position of these 2 officers. Mr. RIMMER was not informed of these officers' misconduct under what is it, Gigolo versus the United States, I believe, which says that this, and he wasn't informed. So therefore, when the officers got on the stand and testified, he really couldn't do nothing but sit there, because he didn't have no knowledge of it. But the thing about this case that's so interesting is what took place. in the robbery with Rimmer, I don't try to speed this up. In the case that Rimmer was charged with, it was about three other individuals that was also involved. One of the guy's brother had went to the car dealership to buy a car, and basically, I guess it's supposed to be him setting it up or whatever. Next thing you know, they came in, the robbers came in, and the proprietor of the place ran out into the street being chased by a guy, and the guy shot him, and supposed to went in his pockets and told the witness, "Get back or I'll shoot you too," or something to that effect. Okay, now the guy that went in to buy the car, he's down at 1300 Bobian or whatever. And what you had happen right after that is somehow, I guess he was released or whatever, but he came up dead. Okay. So his older brother was the other guy that was involved in this case, but he had other cases too. So he was in the county jail. And next thing you know is that he allegedly made a statement or told the police what's supposed to have happened. Now Harris and Haidys tell this guy, "Look, the person that killed your brother was Rimmer and the co-defendant." This was not true. So when the guy, what happens is like this guy, he's in the police station, and Harris called him out the county jail over to the police station and talked to him. And then they called this other guy that was present at the crime, little 16-year-old guy. And Harris and this 16-year-old guy, he told him, "Look, we need you with the other person who little brother got killed. We need you to set up the other guy that was involved in this. Tell him you got a robbery up and for him to let you know if he could do it, get with you right now, because you need to know right now." So he did that and went over to the guy's house, not knowing, the other guy not knowing that this is set up. He come out the house. Harris and his co-workers swooped down on him, and the guy tried to run. They arrested him. He had a mask and a .38 revolver they found. So they arrested him and put him in the car, take him down. They get down to 1300 Bowman. Lo and behold, the guy whose little brother got killed is sitting in a room with, and then the little 16-year-old guy, he's already in the room. So when they bring the guy in that they just arrested, Harris tell them, he put him in a room with the other two guys. He said, "Look, I don't want y'all. I want Rimmer. So y'all sitting here and y'all get y'all story on Rimmer." Each one of those guys wrote a statement out then implicating Rimmer. Rimmer was arrested the next day, and he'd been in prison ever since. But the irony of this is that the co-defendant that they set up, this guy, he sat next to Rimmer at trial because they was charged together. Now at trial, while he's sitting there with Rimmer, it's like Rimmer saying, James Harris get up on the stand, and he says that the co-defendant and this other guy, they made these statements, you know, and the co-defendant, he's sitting there, he can't sit there, and it's like Rimmer was saying, "Well, why don't you get up there and tell them this is not true?" But the co-defendant can't, because he's saying, "I'm invoking my Fifth Amendment right to remain silent." Mm-hmm. So when he do that, Harris get up on the stand and read his statement incriminating Rimmer, but they blank out his name. But you know, it's only two people right there in the courtroom, you know. And so when Harris do that, the jury believe him, okay? And Rimmer get convicted. But prior to him getting convicted, the first day of trial, the other guy whose little brother got killed, that's supposed to set up the robbery, he called Sergeant Haidys and tell him, he said, look, I don't have no way to get down to the court to come in and testify. Okay. Now, it was something that took place there, because what Haidys did, he ran to the courtroom and wrote out a police report to Timothy Kinney, basically telling him, look, I talked to this witness, and he told me he didn't want to be labeled as a rat, so he was not coming in to testify. Okay, so now the judge, he said what? And he have Haidys get on the stand, and Haidys repeat that, right? Unbeknown to Haidys, the guy walk in the door. Now, Haidys told them, he said he wasn't coming because he didn't want to be labeled as a rat testifying. He come in the door, and the judge put him on the stand, and he tell the judge, look, I didn't tell Haidys that. What I told Haidys is that I didn't have a way to get down to the courthouse. Okay? But what he also told Haidys is, look, man, I lied at this guy preliminary examination, basically, because he got on the stand outside the told the jury, told the judge, listen, I lied at the preliminary examination. The reason why I lied is because Sergeant Harris and Haidys told me that these two defendants was responsible. They the ones that killed my little brother. And this is why I testified at this guy's preliminary examination. I wanted revenge. I was mad, but Mr. Rimmer did not do this. I lied at my preliminary examination. Now, the judge, he said, hold on. And he tell Haidys and Harris, you do not talk to this witness ever again. And they trying to explain, well, Judge, I said it's order. Y'all don't talk to this witness again. Now, he tell the witness, he tell everybody, what I'm going to do is I'm going to allow his preliminary examination to be read to the jury. I'm not going to allow what he just told me to be read to the jury. Okay? Now, when he do this, after this guy testify outside the presence of the jury, the judge asked him, do you want a lawyer? Because I think I should appoint you a lawyer to advise you, of your rights. I said, okay. And so the judge got him an attorney. And so the guy come back out and say he want to invoke the Fifth Amendment. But I think that's a little too late. You can't invoke the Fifth Amendment, or the judge can't ask you if you want an attorney after he'd heard your testimony. This should have been done before. And also, the jury should have heard both of his testimonies, his preliminary examination and what he said then. But the judge didn't do that. He just let him hear his incriminating testimony at the preliminary examination. Now, the reason why this background is so important is because, see, Haidys and Harris, they know how this stuff goes, and they fake these statements. So what Haidys had done, and nobody was aware of it, a couple of days after the crime, 2 police officers go out to this witness house, okay? And the witness show him some pictures. The witness couldn't identify nobody, all right? Now, this was done based on Harris and Haidys' understanding identification. Okay, so what happens is they bring Rimmer in for a corporal lineup, a live lineup. And the witness is there, and the witness said, look, I can't identify no one in that lineup. However, if you can't do no better than this, number 4 will probably be the guy. And number 4 was Mr. Rimmer. Okay, Haidys testified that based on this, it wasn't enough. He released Mr. Rimmer. Okay, now when he released Mr. Rimmer, this is when Harris go to work getting these statements from them other guys, right? And when we put them in the room. Haidys, we don't find out that a photographic identification was done. And I didn't, I'm reading the transcripts at the trial closely. And the witness got on the stand and he identified the guy in the courtroom, the two guys in the courtroom. I can't remember what he said about the co-defendant, but about Rimmer, he identified. And he said, they had showed me some pictures at my home, and I couldn't identify nobody, so went to the lineup, and Now, nobody objected to this situation here because the defense was never told that a photographic identification was set. When Sergeant Haidys get on the stand, he said, he admit, I'm the officer in charge of the case and everything got to go through me, blah, 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 blah. And they asked him, okay, well, who was the two officers that went out to this witness house? Haidys said, I didn't send no officers out there. 50 years later, don't nobody know who these two officers was that took these photographs out to that witness and showed them to him. This was the whole point. So the witness could get an image of Rimmer in his head, although they showed him 5 or 6 pictures, right? When Rimmer go to the live lineup, it's clear because the witness said, hey, if you can't do no better than this, number 4 will probably be the guy. That's because he just seen photographs in that illegal photographic lineup that were never told to the defense. And they don't find out about this until trial. And the lawyers act like this was no big deal. But see, this is what Haidys did to this witness. And that was the only witness to this crime. All right. Now, and what he did to the told the court the day of trial about this witness don't want to testify because he didn't want to be labeled as a rat. The guy came in and said that wasn't true. I didn't tell him that. So now you got Haidys lying here, and you got the photographic identification, which nobody know who these officers was. See, now when you take that, Rimmer get convicted. The information about Haidys and Harris' misconduct of beating little kids and calling them racial slurs and basically killing another law enforcement officer. Had Rimmer knew about this when these two individuals got on the witness stand, just like any other witness, they could have asked them, hey, you ever been charged with, blah, blah, blah? Because, assaults and murder all fall in the same category when you're talking about impeaching a witness, okay? So since he did, the prosecution didn't tell him, he got convicted. Now, the co-defendant that sat there with him, he got convicted too. However, the Michigan Court of Appeals of Supreme Court reversed this conviction because Judge Haidys told the jury about the co-defendant's confession. He said, look, I find, the statement to be true or whatever, he said, I find. And so therefore, he didn't say I find it to be true. I'm not going to go that far. He said something about, I find the statement to be admissible, and that's what he told the jury. Now, the Court of Appeals reversed the co-defendant's case, saying that the judge should not have told the jury that because he telling the jury what he find about the statement, okay? And they reverse his conviction. Now, when they get back down there, Judge Haidys said this applies to Mr. Rimmer too. And now it is case law to that effect. What one get, the other's supposed to get. The prosecutor appealed that decision, and the Court of Appeals took away the reversal for Mr. Rimmer then, saying that the issue on the instruction only applied to the co-defendant, but it was the co-defendant's statement that got Rimmer convicted. And he could never cross-examine him because the co-defendant took the Fifth Amendment right to remain silent. But Rimmer had a Sixth Amendment right to confront his accuser. He couldn't confront him because he invoked his Fifth Amendment. So the only person that they could get to come in was Sergeant Harris and said, look, in so many words, look, I'm a police officer, and you know that I wouldn't get up here and lie to you. This is what these witnesses said in their statements, and they believed it. You see what I'm saying? And they convicted him. But Harris, had we known that Harris was a dirty, low-down, murdering police officer, then the jury may have decided, we don't believe this guy. And if they would have known what Haidys did, they would say, we don't believe. But that was the only evidence, because the one guy, he recanted in the courtroom in front of the judge and said, my preliminary examination testimony wasn't true. And he told the judge why. He lied at the preliminary examination and everything. The judge decided to go the other way. Now, when you have this here, the other little 16-year-old guy, he get on the stand and he testified. But the important thing about him is Harris said that in his statement that the 16-year-old said RIMMER was there and he ran out there shooting this guy. The same thing that the co-defendant said. The same thing that the guy whose little brother got killed said. And this is strange because Harris put them all in the same room and told them to get their story. And they wrote out, and the next day RIMMER was arrested. So this is how he get convicted. Now, the problem here in this case is that there was no evidence independent of Sergeant Harris and the other police officer, because everybody denied their statement except for the little 16-year-old guy. He said, look, I did not tell Sergeant Harris that RIMMER ran out there and shot this guy. Harris is lying, basically, okay? The co-defendant has, the 16-year-old guy now today has done an affidavit saying that that was some garbage, Harris lied, et cetera, et cetera. The co-defendant has done an affidavit saying that RIMMER wasn't there and that Harris is the one that wrote out these statements, and he said that I signed my name to it, you know? And this is where RIMMER at. There's no one else involved in this crime that's in prison. Everybody been, the only one that went to prison on this was RIMMER and his co-defendant. And 2 years later, the co-defendant get a new trial. See, so RIMMER the only one that been in there for 50 years, and there's no testimony except for the testimony of these two corrupt cops who the jury believed simply because they were police officers. And the case law clearly tell you that when a police officer get on the stand, he must be careful as to what he said, because the jury, just by the weight of him being a police officer, will take his words to heart. And that is what happened here. And now we know that the officers was liars. But now they're telling us, look, you can't use this testimony against them in this motion for relief from judgment, because it would be inadmissible at a retrial and it would be inadmissible now, because of the fact they trying to say that we saying other bad acts testimony from these two officers, and they saying that would be admissible. I don't give a damn what y'all want to call it. I call it impeachment evidence, you know, and any witness could be impeached. See, but they trying to flip it and say we trying to bring in other bad acts. No, I'm trying to bring in what the prosecution failed in his duty to do, to notify us of these police officers' prior misconduct. Had you did that, like the law says, when they got on that witness stand, they could have been confronted here, okay? So when you took that away, you cannot now come and say, you trying to raise something 40 years ago and say that it was, you trying to say that these officers' prior bad acts should be admissible. I'm not saying that, y'all the one that's saying that, you know. So the funny part about it is when we file RIMMER motion, so now we're going to get to it. When we file RIMMER motion for a new trial, we raised quite a few issues that hit hard. They appointed a prosecutor, and well, first what they did, Valerie Newman, she ran to the judge because the judge ordered them to respond in 56 days, unbeknown to the defense or anybody. Valerie Newman from the CIU hollered and asked them to take that case and hold it into abeyance while the ICU investigate. The judge signed his name and agreed to do it. Just by happenstance, I can't remember how, we found out about it. And we shot a motion in, and the judge, he took that back, you know, and so we don't want the CIU nowhere in here. And so that got them out of there, and the prosecutor answered. And what he answered to was so ridiculous. I filed a motion, a response, and I told that judge, I said, listen, this guy, he's using old law. This law is no longer valid that he's using. And I explained to him that People versus Swain in 2016 changed the whole procedural landscape in Michigan. This guy, the judge, and this guy, they said that I was crazy, that we didn't know nothing about Brady. We had misunderstand it, and that's why the lawyer at trial didn't object to it, because he understood Brady, you know. So okay, we accepted that. Now, when the judge issued his opinion, this man, he issued an opinion. It's like, if the prosecutor's brief was 25 pages when he responded, the judge's opinion was 25 pages when he denied the motion. And every word, except for about maybe 7 to 10 words, was the prosecutor's brief. It wasn't an opinion by the judge. It was the prosecutor's brief. And the judge somehow adopted this brief and made it his opinion. Now, there's no law in Michigan that calls for this. The closest thing you would come to is in federal court when a guy filed a petition for writ of habeas corpus of 2254. And the judge, by statute, federal statute, could appoint a magistrate judge to do a report and recommendation. The judge could accept some of it, part of it, or none of it, or accept the whole thing and make it his opinion, okay? But that's by statute. You got the authority to do it, okay? And there's no conflict there because that magistrate was appointed by the judge. But here, you got an adversary process in the state court where the prosecution and the defense are adversaries. And in the middle, you had a judge who's a referee. He don't take no sides. So how could you adopt that prosecutor's brief as your opinion? And you don't change nothing.
Right.
You don't change nothing. What that is like about 3 lawyers told me. They told me that's plagiarism, you know. But I took it a step farther. I view it as he pierced the veil of impartiality. See, because you're supposed to be a judge, a referee, and you're supposed to look at both sides' argument and do a report, finding of fact and conclusion of law. And he said, after reading all transcripts and all of the motions and everything in this case, I'm denying the motion for relief from judgment. All the way down there. But it's a glaring problem there. One of the glaring problems is the fact that in the prosecutor's brief about the two witnesses that did affidavits, they said after 45 years, these guys want to do affidavits to try to free a friend of theirs. We cannot determine if these affidavits are true because we do not have the defendant's trial transcripts and stuff, okay? Now, if you don't have the defendant's trial transcripts and, you know, how could the judge say after reading the transcripts, et cetera, and say this is his finding of fact and conclusion of law when it's the prosecutor's brief? But how could you say this if you don't have, or if you didn't have the transcripts? I'm sorry, I put this down. if you didn't have the transcripts. See, so you made a statement about 2 witnesses, but you say you don't have the transcript to see if the affidavits, they are telling the truth, compared to what went on at the trial, right? But you don't have the trial transcript, but you make a decision and you said, well, this guy testified to this and this guy testified to that. And that's from the prosecutor's brief. A judge is supposed to be impartial when he makes decision. He's not supposed to take sides. But here, this judge, he not only pierced the veil of impartiality, he took the prosecutor's brief and made his finding of facts and conclusion of law, not just at the end, but at the beginning. At the very beginning, the whole opinion is the prosecutor's brief. If you put them side by side, you wouldn't be able to tell the difference except for down at the bottom where the judge got his signature, dated for February the 9th, 2024. That's the only difference in the two. And so we did a motion for reconsideration, and we was explaining to him the issue at hand is that the defendant did not file a motion for reconsideration, because that's what the judge said in his motion. The motion for relief from judgment was. We filed a motion for relief from judgment, not a motion for reconsideration. And so that was one of the things he did. And then it said the judge erred when the court failed to make an independent finding of law, where the court adopted incorrect aspects of the prosecutor's brief as a report and recommendation, denying the defendant due process of the law. Adopting incorrect legal theories in a prosecutor's brief cannot be a substitute for a court duty to impartially assess the case. And he haven't answered that. And then he told him made another error. The court erred when it conflated defendant's Brady claim with People versus Kratz. Well, February the 8th, this is the day before he denied RIMMER motion. February the 8th, 2024, this court was reversed by the Michigan Court of Appeals for committing that same error. Defendant raised the claim of newly discovered Brady evidence. The court reviewed the claim under Kratz, newly discovered evidence. And this is what the court told him when they reversed him the day before. Defendant continues by stating the facts of this case. In his opinion, defendant concludes his argument by asserting that the prosecution has incorrectly cited or relied on outdated provisions of the court rule. Now, this is what the judge said to RIMMER. Defendant argues that the prosecutor failed to research the concurring opinion and refused to conclude that important aspect as it would contradict its assertion. Now, this is what the judge, I guess he called himself getting on us, But the problem in it is that this is what the Court of Appeals said to the same judge for the same stuff the day before. More importantly, the categorical rule described by the trial court is fundamentally inconsistent with our Supreme Court later binding decision in People versus Route 491, Michigan, holding that under Kratz, when the defendant is aware of evidence before trial, he or she is charged with the burden of using reasonable diligence to make that evidence available and produce it at trial. And further holding that what constitutes reasonable diligence in producing evidence at trial depends on the circumstances of the case. Now, that is true. But the problem in this case is that Brady versus Maryland don't have no diligent performance that a defendant got to do. Brady versus Maryland and the Michigan Supreme Court reversed itself in a case called People versus Chenault in 2012 and said clearly, under Brady versus Maryland, a defendant does not have to show diligence as to what he did to bring this issue. That's state law. That's under Kratz. Under Brady, you cannot take Kratz and use it to deal with the guy's suppression issue simply. And it's real simple because of the fact when you do that, what you have is Kratz's state law, and Kratz says you must show diligence. It's a 4-pronged test. Now, if I'm raising a Brady claim and you use Kratz to knock me down, Kratz is not superior to the United States Supreme Court. And so this is why this guy got reversed on that, you know. And I had told him in there, this court has conflated Brady and Kratz claim. See People versus Milton, concurring. Though Brady claims and Kratz claims are often intertwined, trial courts must address each claim separately, you know. And this guy, he's sitting up there now with this stuff, and he don't know what to do because we got him locked in. He don't know what to do. The Court of Appeals, they already told him he's wrong. And the other problem that they are doing is at the beginning of a successive motion for relief from judgment, they are making you come through Kratz again. And the court is saying to him again, look, on a successive motion, at the opening stages, you cannot use People versus Kratz at the beginning of a successive motion. You cannot. So now you got them taking Kratz and using it when you file a successive motion, and you got them taking Kratz and using it for newly discovered evidence on Brady claims, you know. And the court's telling them, look, you can't do this. I got about 25 cases since 2016 where, and in this Wayne County only basically, where they'd have been reversed in orders or in applications. In Michigan Supreme Court, every case, I don't care how short it is published. It's in a book. It may be back in the application, but it is published. The Court of Appeals opinions, all of them are not in the book. Only the published opinions are in the book. So what the courts have been doing is issuing these unpublished opinions, knocking these judges in the head, and the people that's sitting in prison don't know about these little orders in the back of the application where they checking these judges, sending cases back. See, don't nobody know about that, because if it's not published, guys figure, well, I can't use it, you know, but you can. And see, this is where they's hitting these guys in the head. They using Kratz for the guy Brady issue, and they using Kratz at the beginning of a successive motion. And they are being told over and over again that, you know, you can't do that, you know, you can't do that. And see, the judge and the prosecutor in RIMMER case, they tried to use to stop the money if RIMMER you know, will succeed. The way that they was going to stop the money is to say, look, you can't use their testimony because MRE 609 says you can't. And this is what the judge said. Further, the exception found in MRE 609 is obviously inapplicable because it requires a conviction, and the two specific instances of misconduct that the defendant is discussing are acquittals. The mere fact that two officers involved in the defendant case were acquitted of charges is in unrelated trials was not evidence of any kind in this case. Similarly, that evidence could not have been introduced to attack their character. Accordingly, the people did not suppress anything. Now, I don't know how you come to these kind of decisions, because in the same thing that he's reading, I read in it. And like I said, here the court and the prosecution has asserted MRE 609. However, the defendant contends that MRE 609, it don't apply. It don't apply at all. And the case is People versus Latner. Moreover, charges that do not result in convictions are admissible for impeachment and bias. People versus Latner, 464 Michigan, 2001. So here you go again. The prosecutor brief says that those officers' prior misconduct, it can't be used under MR 609. But that is not true. That is not true. And when we pointed this out to him, what Latner said, and this is what the court said, we granted leave limited to whether the trial court erred so as to require reversal and allowing the prosecutors to cross-examine a defense witness concerning a prior charge for which he was acquitted. We conclude that the overly broad holding in People versus Faulkner, which states no inquiry may be made regarding prior arrests or charges against a witness that did not result in conviction, is inconsistent with precedent and with the approach to the admission of evidence that we have followed since the adoption of the Michigan Rules of Evidence. We hold consistent with the existing law and the Michigan Rules of Evidence that a trial court may allow inquiry into prior arrests or charges for the purposes of establishing witness bias. And that's People versus Latner,
Right.
So all of this, see what you have, and the reason why I went at them so hard on this is because I want law in Michigan, not unpublished decisions, need settled law, because these judges are taking this stuff and they know. See, the problem with a relief from judgment and a guilty plea is this. In a guilty plea, for example, judges know how to play this. See, because you don't have no right to appeal a guilty plea, so they could trick these guys into pleading guilty. And when they come back on a relief from judge, they don't have to come back on a relief from judgment. They could go to the Court of Appeals on application, and the court is going to say, leave to appeal denied, because you don't have no right to appeal. It's up to the court to use discretion on an appeal of right. On a guilty plea. Now, when you get a guy who got convicted and he's filing a relief from judgment, and he filed this relief from judgment up in the court, and the judge knows, okay, he filed a relief from judgment, so he don't have a right to appeal. So he's in the same position as a guy with a guilty plea. So I can say anything I want in this motion and denying, because when he take it to the Court of Appeals, 99.9% of the time, the court is going to say, leave to appeal denied. We are not persuaded that you meet the criteria MCR 6.508. See, so
Right.
You never get into the court. So your conviction is going to stand. And this is why in every motion that I'm filed, I don't mean to be taking up all y'all time, but this is why in every motion that I file now, I don't file motion for relief from judgment. I file that as a secondary. I file defendant's motion for a new trial pursuing the MCL 770.1 and 2 / or in the alternative, motion for relief from judgment pursuing 6.500. Okay. Then I do an issue on the 770.1. See, because they don't want you to come in on the 770.1. And that's why they came out with relief from judgment October the 1st of 1989. Because under 770.1, a defendant could file a motion, then he could file another motion, and they put a stop to that. So they put up this weird procedure, 6.500, which, let's be honest, guys in prison, you know, they don't have the ability to navigate through that procedure nightmare of 6.500, 6.5 or 1 or 2 or 3 or 4, and then the subsections in each one of those sections. See, guys don't, they don't know how to deal with it. So what I'm saying is that under MCL 770.1, a defendant would be heard on a, you know, on a relief from judgment under 770.1 in regards to what these judges are doing, because they know a defendant cannot get in. The rules are so tight on a 6500 motion until the judges, they just deny them and deny them and deny them. And a guy is lucky to get past and had a court hearing. But normally this is not going to happen. But under MCL 770.1, a judge could grant a motion for a new trial whenever that judge feels that justice has not been done. Mm-hmm. See, whenever he feels just, and in Swain, the trial judge found 1, that they suppressed evidence under Brady, 2, that she was actually innocent, 3, that justice has not been done. Okay. Now, the prosecutor appealed that to the Court of Appeals. The Court of Appeals took that away in 2015. Okay, in that Swain, that is an unpublished opinion, and it's long as hell. So it is too an unpublished opinion. Now, what happened is that there was a concurrent opinion from this lady judge, I think it was Glacier or something like that. She said, okay, I agree that Michigan do not have an actual innocence standard. I agree. And she said, however, I will reverse this conviction regardless of the MCR, blah, blah, this and that, because it is clear that this lady is innocent. And she said, but my hands are tied. Okay. Now, the prosecutor, when we raised this in RIMMER's case about 770.1, he got all sarcastic and he said, yeah, there's another defendant who tried this and was shot down. See, People versus Swain, November the something in 2015, where the court rejected this claim, okay? But what the prosecutor did not do, he did not put that concurrent opinion, okay? Now, that concurrent opinion in the 2015 Swain caused the Michigan Supreme Court to grant leave. And when they granted leave on 6 issues. But I'm going to go down to issue 4, I think it's 4 or 5. And the Michigan Supreme Court basically asked for the parties and the friend of the court to brief the issues. 1, does Michigan have an actual innocence standard? If it don't, is there a procedure in 6.500 that will conflict with it? If it does, is there's a procedure in 6.500 that will conflict with it? And if it don't, basically, does it conflict with any other law? Basically. Then number 6, they granted leave on this. They said to brief the issue whether or not the defendant could file a motion for a new trial pursuant to MCL 770.1 instead of MCR 6.500. Okay. Now, they didn't get to answer 4 to 6 issues because they granted Swain relief on the first, that it was a Brady violation and that she could file a successive motion for relief from judgment. But the part of their opinion in 216 Swain that's so important, they said we remand this case back to the Court of Appeals for a finding not inconsistent with the trial court. Now, what that is saying, whatever you do, Court of Appeals, when you send this case back, it must be consistent with the trial court's findings. Now, the trial court found that there was Brady violation, that she was actually innocent, and that justice has not been done under MCL 770.1. Okay? Since they made that ruling, and since Swain is at home with a couple of $1 million in her pocket, then somewhere she was found to be innocent. And the fact is that they remanded it back for finding not inconsistent, and the not inconsistent part entails that justice has not been done under MCL 770.1. It wasn't nothing about MCR 6.508D3 or any of that stuff. The judge found that justice has not been done. Thus, the Michigan Supreme Court did rule on MCL 770.1. You see what I'm saying? Because of the fact when they remanded it, they said not inconsistent with the trial court's finding. And if the trial court found under 770.1 that justice has not been done, they in effect embraced Swain's argument and the trial court's finding. So now anybody should be able to go back in the trial court and file a motion for a new trial under MCL 770.1. Or in the alternative, the court ain't gonna go for relief from judgment. But they keep trying to say in other cases that the Michigan Supreme Court overruled MCL 770.1. And I find that to be impossible, because the Supreme Court can't overrule the legislature. They could only send it back until the legislature, it don't pass constitutional muster to fix it up or whatever y'all gonna do. But they can't overrule. And see, the reason why that's true, MCL 770.1 is still on the damn book. But the Supreme Court instructed all trial courts, anytime a guy filed after his original conviction, the only thing he could file is a motion for relief from judgment. Now, I wonder, where did a court rule start overruling the statute? See, so the statute is still on the book, and this man is sitting in prison when he's actually innocent. I won't even go to say he's actually innocent. I'm just saying this man needs a new trial because there was no evidence against him, and he got convicted on this. And that's what's happening with the RIMMER case. He's sitting in prison right now for a crime he didn't commit, and 2 lying police officers who was arrested for assault on black kids and calling them rivers, and the other officer who shot a Wayne County sheriff that, well, he was aiding and abetting with the murder. So killed another law enforcement officer, wounded another one, and beat some more, because the guy from the Big Four come in. And he said, no, don't hit that. No, I know these guys. They sheriff that. Harris said, we don't give a damn. And he kept on beating. This guy, Benson, I think it was Captain Benson or something, he pulled out a sawed-off shotgun and put it to the back of that police officer's head and said, you hit him again, I'll blow your damn head off. Now, how is a police officer going to tell another police officer this? And you gonna tell me I can't use these guys' misconduct to impeach them when they got on the stand and said these witnesses made these statements, and the jury believing them because simple fact they are police officers, and to me they are no better than any other witness. And the court got the law mixed up, and the prosecutor, I mean, come on, judge, you know damn well that the prosecutors misconstrued things in their briefs and all of that. That's why you the damn judge. But for you to accept his brief and cross his name out, really, and put your name on it and say motion for new trial denied, there is something seriously wrong. There's no case law that I could find anywhere that says the judge has a duty or he can give up his impartiality. and be partial. That's no law nowhere in the country,
Right.
and that's where we standing with this. And I think that this judge, me personally, I don't care when he ruled, but Diane don't do it. Because it'll be a welcome to me to take this back up into the court, because I know probably won't get leave in the Court of Appeals. But one thing I know, I secured this guy to file a second petition for a writ of habeas corpus. See, and that is the main problem that guys have, and guys don't know it, that if you come through the state court and you raise newly discovered evidence, you can raise it all day in the state court. But guess what? When you file a petition for writ of habeas corpus, they're going to tell you newly discovered evidence is not a federal constitutional claim. So therefore, we can't entertain it. And if people think I'm lying about that, all you got to do is ask Crest or read Crest versus Palmer. When Crest, and see, Crest is so big in state law until guys think Crest won. Crest lost. And he went to the federal court on a petition for a writ of habeas corpus, and the feds told him, look, newly discovered evidence is not a constitutional claim. And they was telling him, look, we know that you're probably innocent, but your claim of newly discovered evidence is not a constitutional claim. You got another remedy. Go to the governor and ask the governor to pardon you or whatever. And that's how Crest get out of prison. See? But if you got to bring that in the state court and put them up against the wall and raise an actual innocence. And when you do that, the problem that they're going to give you is that they're going to make you come through Crest, right? And to file your motion or whatever. And the problem with that is Scheller versus D-Lo and House versus Bell, the controlling cases on actual innocence, clearly tell you, if you raise a true actual innocence claim, there's no procedural bars. So if I raise a true actual innocence claim, now remember that concurrent judge in Swain said, I agree, Michigan don't have an independent actual innocence claim. So if I raise an actual innocence claim in Michigan, they're going to make me get in the boat with Crest. And I can't do that because Scheller versus D-Lo says there's no procedural bars. And if you look at Crest, the first one, newly discovered evidence must be newly discovered. Okay. And if it ain't, you can't get in. That's a procedural bar. The second one, it must not be merely cumulative to what happened at the trial. That's a procedural bar. 3, you must show diligence why you didn't raise this issue. That is a procedural bar. Then 4, you can only win if you show that the results of the proceeding may have been different. That is a procedural bar. It go 100% against Crest. When you raise a true actual innocence claim, there's no procedural bar. So this is why guys can't raise actual innocence claims in Michigan. When they do, the court can screw it under People versus Crest, newly discovered evidence. So when they do that and you try to go into the feds, even on a relief from judgment, you're not going to get there because you raised the newly discovered evidence, and feds don't recognize that. And I don't understand why Michigan don't get it, because they told them that in Suter versus Jones. Look, Michigan, you can fuse actual innocence with newly discovered evidence. And that's what they told them. You can fuse the two, and that's what they are doing. See, so they lock you out by misconstruing your actual innocence as newly discovered evidence. And then when you go to the feds, they say we can't entertain it because it is newly discovered evidence. You see what I'm saying? So this is where we at, and it's not that these guys don't have the issues. What it is, they use procedural law to keep these guys in prison. And that's all it is, procedural law. You are not entitled to relief because the evidence that you're saying is new, you knew about it before trial. But the feds tell you every Brady claim is that. Okay, I'm done. I didn't mean to take up your time like that.
First of all, Mr. Travis, you have just broke it all the way down. And for people who are like Mr. Ricky, and they're having these issues, you made it clear on the reason why they're having these issues. So hopefully, because I hear about the 6,500 all the time, and doing appeals and stuff. And so you gave a great explanation on things you can do to go around it. And so for those who might listen to this later, I would say go back and get these tools, because you gave so many good tools on how to work this system. And then also this judge, Revatia, you had something in the comments about this judge.
Yeah, Judge Christopher Blount, is filling a vacancy, and for Wayne Circuit Court that began April 18th and supposed to go through January 1st. But from my understanding, and you can correct me, he will have to run for re-election in November if he chooses to serve the remainder of Hood's term, who he replaced, and that would take him through. If he runs and is reelected, and is elected, he will be in that seat until January of 2027.
Yeah, I know he would have had. I thought he had already got that position, but this guy here, and I don't know if I should talk like this but I mean, he's just the uppity Negro. I mean, I'm just gonna call it like it is. I mean, the whole family is part of the police department. Me, since I'm working on this case, I said his daddy was a crook too. His daddy was on stress with James Harris. And then in 74, when Coleman Young come in the office, Coleman Young take both of them and put them on his protective team. So if he did that in 74, they was hanging out until one of them left. Now, I know Harris didn't leave voluntarily. He left in handcuffs from the FBI and when it did 20 years. So I wonder, where do that put Judge Blount, where his father was working with this guy closely? Now, Stress wasn't no hell of a unit, because I think they only had about 4 black guys on it. So you can't tell me that Harris and Frank Blount was on Stress and didn't know each other. Because if that's the case, when they both went over to Coleman Young's detail in 74, they didn't know each other then. And if we want to take it farther, when all of that corruption came down with Coleman Young's niece, etc., I wonder if Blount was anywhere in here. I wonder if Christopher Blount denied this man motion because a friend of his daddy's was being accused. I don't know, but all I'm saying is look into it. The public got a right to know. They got a right to know. Now, Christopher Blount, you sitting up there, you'd already plagiarized the prosecutor's brief and made it your opinion, and now you got this drug murder type of situation concerning your father and a convicted drug dealer named James Harris. Gil Hill was involved in it. Got him on tape talking about, I want to meet the guy that the FBI undercover officer just so happened they arrested him before he met with them, and that's how Hill came out clean. But it's a lot of dirt on these police that was on that Coleman Young's detail. And when it connects like this, and now I got a judge up here denying a man that's been in prison for 50 years based on really solely the testimony of Lieutenant James Harris, I think an inquiry needs to be made. And I don't even think that's fair. You know, I'm not saying he denied this guy motion because James Harris is a family friend. I don't know if he a family, but I'm saying what she said today. If that bird looked like a duck and quacked like a duck, it's a duck. And that's all I want to know. Is this possible? Because it's too much corruption down in the Detroit area, in the Detroit Police Department, where they suppress evidence and suppress it and suppress it. And then when the defendant find out about it 15 years later, actually to me, it's nothing but another form of qualified immunity, you know? Because if you're not going to allow me to impeach people that testified again, you know, I bet you if this was a case where it wasn't involving police officers, and, you know, it wouldn't be this hard, you know, but for some reason they want to protect the police the same way that other, I don't know what to call him, left the deputy's mayor office and went down and became chief corporation counsel. And the first thing that he did was tell them in that office, anybody come in here looking for information on a Detroit police officer, Wayne County Sheriff, or whatever, listen, well, Detroit police officer, listen, if their misconduct or conviction is over 4 years, they are not to receive that information because I believe everybody deserves a second chance. What? So you ain't gonna give up these police misconduct because you feel that 4 years is too long? Well, hell, Rimmer's sitting in prison for 50 years. You know, so I just don't get a lot of this. And a lot of these lawyers, and I'm going to be frank, they not doing their damn job when these guys get arrested and come through there. They are not doing it. They are not requesting this discovery stuff. Kim Worthy said in 2017 or 18, she said, in 2 years, my integrity unit has found 30 convictions of people that's innocent. Now, if you found that in 2 years, well, I'm scared to think what you will find in 3, 4, 5, and 40 years. You know, the problem here is that the 2 years that she said 30 convictions, so we know it's at least one officer on the case, but we know it's 2. So that would mean those officers on those cases, somebody got to be prosecuted somewhere. And you can't continue to protect these police officers like that. You just can't. And that's what I feel. Look, I don't care what Blunt do, you know, because this here has to stop. It has to stop, you know. And Kim Worthy that got so slick when she released all of them guys, she released them without prejudice. Now you got guys been sitting out there for 5, 6, 7 years wondering if they're going to be prosecuted, you know, but they scared to bring a motion for that woman to show cause, you know, and that's all you got to do. But these lawyers, they scared because the judge, like Blunt, appoint cases to them, and you don't bite the hand that feeds you. I can understand that. But damn, this is the public. And he's supposed to be working for the public. All of them supposed to be working for the public, you know? And I just don't get it. Kim Worthy, she come out the crime lab in disarray. She come out with a memo saying simply, if your case happened before 2004, I'm not going to entertain any issues concerning the crime lab. Okay, fine and dandy. But who gave you the authority to make the determination as to who get due process and who don't? You just a policy maker. You can't make those kind of decisions. And when she did that, she stopped guys from filing because they took that as being what it is. But The problem she had is in 218, I believe, People versus Ricks. Her and the defense, they agreed that Ricks was wrongfully convicted, and they gave him all of that money. But Rick's case took place in the 90s. And Kim Worthy lied because she told everybody, that if the case is before 204, I'm not entertaining it. So since she's entertaining it now in Rick's case, and his case happened before that, everybody else, and I'd have told guys, what you should do is take that Rick's case, attach it, and say newly discovered evidence. Because that's what that is. Since she released Rick's, and his case happened before 2004, then whatever happened in his case, a defendant could use and say, this is newly discovered evidence. Because Rick's crime lab thing happened in the 90s, so did mine. But Kim Worthy want to give we are similarly situated defendants. And she want to give another defendant this rhythm and not give it to me. That's a denial of equal protection of the law. So again, I say this because I don't believe these damn lawyers doing their job. I really don't, you know. And really, that's all I got to say on the matter, because I don't deal with these other guys running around here talking about I'm an innocent project, I've been locked up, and now everybody running around with jackets talking about they the innocent coalition and all that. All they doing is selling their fucking brand, you know, and going sitting on a yacht with Kim Worthy, donating. What the hell is this? I tell them to their face, don't come around me with this nonsense. Y'all ain't trying to help these guys get out of prison. Y'all out here trying to look good to these white folks out here and say, Kim Worthy, I'm on your side. You even had one of these idiots running around with this 9,000 or one of these groups, and elderly sister's supposed to got attacked and raped. And he out there with one of these groups, and they go chase a guy down and beat him and everything and arrest him, and he ain't even the guy that did this. But you was in prison, wrongfully convicted, and you bring your butt out here working with them, and you get somebody arrested that didn't commit the crime. Now, what could you tell me? You can't tell me nothing. You can't tell nobody to join anything, because y'all not out here to help these guys. Y'all out here to show these people, look, I got me a suit now, I got me a car now, I go to meetings now, you know, and that's some garbage. And they own some garbage. I don't care who or what they said. They ain't trying to help nobody in the prison system. They are not. They only come down to these guys' cases when that little birdie in the prosecutor's office, I guess, tell them, hey, you know, we're going to cut these guys loose or cut this guy loose. You know, y'all could go, what they call it, fire chasing, you know, to see if y'all could get a attorney, you know, where they could get them some money too. That's all it is. And that's what these guys do. And I'm just simply not with it. They not trying to help nobody get out of prison, you know? So they might as well be the judge and the prosecutor their damn self, as far as I'm concerned. But that's where I'm at with that. And I didn't mean to bring in my true feelings about this court system or none of that. But it is what it is. And I just get tired of tiptoeing around the nonsense, because that's what it is, nonsense. You're going to sit a guy in prison for 50 years. 50 years. You know, I even took on a case, about 2 months ago, because this guy he been in prison for ever since 71, because he's supposed to kill the guy in prison about a carton of cigarettes, you know. And I just think this stuff is so out of whack. You know, it's guys don't even know what these people did to them. They look at these people can't understand this here. Guys do not even have an 8th grade education. So you explain to me, just explain to me, how is a guy going to dissect just this one part, MCR 6.502? I mean, it's too much for a guy without an education. How do you expect for these guys to understand something when people like Professional Negro Blunt don't even understand it? And he's supposed to went to school, supposed to went to law school, supposed to, because if you went to law school and you making rulings like you making, something is seriously wrong with the law school you went to. You know, because you're not no judge. All you are is a rubber stamp for white folks down there, where it used to be, well, this judge did this to me, this white judge. Maybe if we had some black judges, you know. Yeah, as soon as you put them up on the bench, they start trying to appease the system. Well, instead of, well, this black judge, this white judge would have gave him 25 to 50. I'm going to show master what I could do. I'm giving you 50 to 100. And this is how this stuff comes out. This is, it don't appear to be that way. It is. You know, people cry about they took recorder's court and abandoned it. I'm glad as hell they took it. I don't have no sympathy for the judges, the black judges that can't get on the bench because they got to deal with the whole county. See, because they are not looking at it for what it is. The legislature said, basically, you black people in Detroit will never really have a chance to convict another white police officer. And why? Because we're going to take recorder's court and make it part of the Wayne County Circuit Court. So the jurors got to come from countywide and not just out of Detroit. So y'all won't get that opportunity. Now, you tell me a reason why, another reason why they abolished recorder's court and made it Wayne County Circuit Court. There's no other excuse, because the white folks control the legislature up there, and it trickled down and they said, look, you know, we're going to abolish Wayne County, Detroit Recorder's Court. And when they abolished it, now you got some white judges and you got these black judges that don't know law. The judges that do know law, that was even-handed, they are not on the bench. It's not because they wasn't re-elected. It was because Kim Worthy sicked somebody on them judges. You know, that's all that was. And people got to look at it for what it was, what it is. Those are not black people down there. Those are professional Negroes. And it's a difference. It is a hell of a difference. You know, and I know I shouldn't be saying this, but I'm saying it because it's true. And somebody needs to tell them. You know, you got another Negro judge up there that just did something stupid. This guy, Dan, what's this judge's name in that case? We went down there and seen him. The one that be using his hands to make. He sat in the prosecutor's office for 15 years. Ain't nobody really heard of him.
In the prosecutor's office. Most of those judges coming in now have been in the prosecutor's office for multiple years, and they're coming in with the prosecutor's perspective on things. And the guy that his name slipped my mind, but we were in his court.
Is it Bradley or something?
Mm-hmm.
Is his name Bradley?
Bradley Cobb.
Yeah, Bradley Cobb.
That's his
now
name.
This guy been sitting down there for 50, and I went down there the first time I go down there in this courtroom, and I'm listening to this guy, and I said, this guy don't know what the hell he's talking about. And then a week later, come to find out he really didn't, because he denied a guy motion. And guess what he said? I don't believe this witness. It's not up to you to believe that damn witness. It's up to the jury. Right. You're supposed to look at it from the point of view, okay, if I was a juror being picked, would this possibly, you know, you ain't supposed to assess a witness credibility. It's not for you. That's for the jury. You know, and that's what they do. They do it all day. They constantly doing it. And this guy Bradley Cobb just did it the other day. And without a doubt, he's going to get reversed on appeal because he just did that and the same thing that Blunt did in RIMMER case. This guy just did it 4 days ago. And they had like, hey, ain't nothing to it. Ain't nothing to it. But that's what they doing down there. They just messing up these guys' lives, you know, and don't nobody care. They just gonna sit back there and collect that $100 and some thousand that they get every year, you know, and send people off to prison. I'd rather go in front of a white judge. Matter of fact, I would rather go in front of an old white judge that used to be in the Ku Klux Klan instead of going in front of Judge Blunt or one of them Negroes down there. I actually would, you know. I actually would do that, you know, because I mean it's no worse. It's no worse. I mean, I might get even more rhythm from the white judge.
Mm-hmm.
You know.
You know, Voice of Detroit has just sent an email to Judge Christopher Blunt asking about his father's relation. His father is Michael Blunt, and he was a retired cop on the Detroit Police Department for 25 years. And what Travis was just talking about with him is that his father, Michael Blunt, worked with James Harris on stress and on the mayor's security team. And I found an article where he's expressing his opinion that stress was the best experience of his life working for the Detroit Police Department. James Harris did the same thing after he came home from prison, talking about, oh, you know, stress did a good job. It kept the streets safer. Crime went down. That's what Michael Blunt, who is Judge Christopher Blunt's father. In fact, Judge Christopher Blunt, his middle name is Michael. That's what he said too. It brought the crime rate down.
I don't mean to cut you off, Dan, but wasn't Michael Blunt under some kind of investigation by the feds or something for a minute?
His father, the grandfather, Frank Blunt, was under investigation by the feds, and at the time, Michael Blunt was living with his father, Frank Blunt, and
So
in the
the
same
whole
they raided their house and with relation to drug trafficking. No charges were ever brought, but so we can't really say.
but that's what I'm
But we
saying.
know what James Harris was doing because he spent 20 years in the federal joint for it.
Yeah, but that's what I'm saying. According to them, there's nothing wrong with the grandfather house getting kicked in for drugs. And then this guy, the father of the judge, is on the stress unit the same time that Harris then killed the Wayne County Sheriff deputies. Then after that, in 74, both of them go to Coleman Young's security detail. And we know what happened after that, you know. So, but it's nothing wrong with none of this. You shouldn't even be able to fix your mouth to say, look, could y'all look into this at least? Because for me, hey, this is just nothing wrong with it. And
Yes.
I don't get none of that stuff.
I put in the link, so if you guys are watching this later on, there's links in the live stream for the actual Voice of Detroit article, and also the two cases you were talking about the sheriffs and the DPD. What was that? The Rochester Street Massacre.
And the Veterans Memorial incident.
Right. So I have those in the link because it is important to know as background during this time how they were operating. The police were operating at this time. They was very corrupt. and it caused a lot of harm to the community. And so if they were doing wrongful convictions from then, if they was able to bring, a lot of those people from that time would probably be out as well because of all the corruptions with that stress. And I know as a young kid, I had older uncles who would talk about the stress and how they would just jump out and beat up people, and they'll just beat you up. So and then from Big Four.
Go ahead.
And after that, they had the Big Four that would drive around in the neighborhoods and jump out and beat up people, So it was the same thing with a different name. The gang squads and all this stuff. But they had a history, Detroit police had a history of corruption during that time. And I wish I had Attorney David Robinson on, because his book
he knows
about that era when he was a police officer and he left during that time to become an attorney, civil rights attorney. So this is really important, you guys. A great history lesson, great information for you if you are really fighting a wrongful conviction. Hopefully Mr. Rimmer would get justice. Also, we have to pay attention to elections. It also shows that when we're voting, you have to pay attention to who's running. If we listen to these cases and we're looking on this ballot and we see, what's his name, Judge Blunt, then you might not want to vote for Judge Blunt.
Well, he might have some problems after he gets these stories.
So these are things that we have to pay attention to. Our local elections are so important, and especially voting for these judges. Some of these same judges just get back in because, we either don't vote for them or we blindly vote or we vote for name recognition. And we have to start doing our due diligence when it comes to that, especially when these judges going down there to that, what's that, 36th district or the 3rd district courts. Some of these judges is not there for you. So
could I add one more thing?
Yes.
I would like for anybody that got or had an officer named Donald Hughes on their case to get in contact with me, because he like beating up 16-year-old witnesses, female witnesses, and making them testify the way that he want them to testify in murder cases. Then take the 16-year-old witness 2 months later down to another murder case where she the main witness and make her testify. Without telling the guy in the later trial that he beat this witness silly. And his Court of Appeals opinion condemning that officer for beating this girl. And what's so funny about it? This officer, he did it again, and he keep on doing it. And he was the officer in the case we talking about that new judge Bradley Cobb just denied, because he don't believe the witness. How in the hell you not going to believe a little 16-year-old kid when you got 4 more people come into a courtroom before trial and testify that they heard the slap and the name calling of the 16-year-old child getting beat by Officer Donald Hughes? And then you gonna let Donald Hughes bring this 16-year-old witness to another murder case? Of course she gonna testify like he wanted to.
And Donald Hughes was the officer in the cases of the exonerees Marvin Cotton and Anthony Legion. They sued him. That's how we found out his name. Kim Worthy, when she exonerated or supposedly, did not oppose their exoneration of the 2 men, she listed all the things Donald Hughes had done wrong in their cases, but did not disclose his name so that people would know his background. Her press release deliberately left out Donald Hughes's name. The way we found out was when we found the lawsuit that Marvin Cotton and Anthony Legion filed. The attorney in that case identified the cop. Now we're getting all sorts of other complaints about him.
So
And the
is
problem
Hughes,
with
so
that-
you're saying, I got a question. So Hughes is still working?
Oh, well, now he's real
No.
sick. He was deposed, and you know, they were trying to say he was too sick now to even, you know, but he got deposed, and his daughter, I think, was there speaking for him too, you know, in that case, you know. But see, the real problem with what Hughes did, it don't fall on Hughes, it fall on Kim Worthy, because when she did not release who that officer's name was, that officer stayed out there for 3 more years doing this stuff, and nobody knew who he was, because Kim Worthy deliberately would not give up his name. Well, not that she wouldn't, she didn't put it in any of the documents. You know,
Yeah.
all she said was he was the OIC, all the way through. And she talked about him like a dog. But you talk about him like a dog, but you don't say his name, don't put his name there, and you don't tell nobody, and you leave him out there for another 2 to 3 years to continue on this kind of. She needs to be
Protect
prosecuted.
him. Yeah.
She needs to be prosecuted for that.
So what's this officer name again?
Donald Hughes.
Donald Hughes. How they get in contact with you, Travis? How would they get in contact with you?
They can do it through the Diane, Voice of Detroit.
Okay.
Actually, we can give my phone number because I've covered some of that information on Voice of Detroit. I can give you my phone number because they might have. Well, my phone number is actually, if people go to the Voice of. All you got to do to get on Voice of Detroit.
Well, see.
Voice of Detroit.
The thing about it that people don't understand is Kim Worthy protect these guys. You got one officer that got caught by the Ferndale police twice for drunk driving. Now,
Yeah, that was Miss Wilson. Yeah.
oh yeah, Wilson. Now, see, the slick part about Kim Worthy them in this is they'll let him plead guilty, right?
Mhm.
Now, if you get caught, let me get caught driving, and I got a firearm. That's a felony during the. Look, come on, that's a felony. That's you got possession of a firearm during the commission of a felony. What they do is they let them plead guilty and drop that felony. See, because that felony firearm, regardless if they gave you life, the felony firearm conviction carries a mandatory 2 years, and you must serve that 2 years before you start on the other bit. See, so that means Wilson would have had to go to prison because he had a firearm in his possession while he was driving drunk, and he got 2 of them. But she never prosecuted him for it. They don't prosecute these guys.
And the other people she doesn't go after is the assistant prosecutors in her office, like Patrick Muscat, who was involved in the Devontae Sanford wrongful conviction, the Thelonious Searcy wrongful conviction, and the there was another exoneree. His name just slipped my mind. All 3 of those wrongful convictions. In the Kenneth Nixon. In the Nixon case, Patrick Muscat told the police in charge of the jail to interview the cellmates of Kenneth Nixon because he didn't have enough evidence to convict him. And that's how he was convicted, on a jailhouse informant. We have written evidence. In fact, there's an article up in Voice of Detroit on Kenneth Nixon's case with the written evidence in Patrick Muscat's memo that he did that. But Kim Worthy will not hold any of those assistant prosecutors accountable, despite the fact that many other prosecutors across the country, in New York, Boston, they have fired prosecutors. The prosecutor in New York, when he got in, he fired 30 prosecutors immediately.
That was in Philadelphia. Yeah, that's a program that everybody should watch called Philly DA.
That's
because
right.
this guy wouldn't put no games. When he came in office, he said, "Look, he said I had 30-something wrongful convictions here, and 30 of you was involved in those wrongful convictions." He said, "I would like for y'all to get y'all coat and get y'all hat and get the hell out of here." He fired all of them. You know, he fired all of them. But you won't get that from Kim Worthy.
No investigation within her office, because those prosecutors are conniving with those cops. They like to say, Kim Worthy and them like to say, well, you know, it's the police that did it. Well, I'm sorry, under the law, the prosecutor is responsible for everything the police do if they don't disclose it under Brady versus Maryland. The prosecutor has the responsibility whether or not they knew. But in many cases, the prosecutors,
tell them how ridiculous of what they just said about what's that prosecutor? The one you just said.
Muscat. Patrick Muscat.
In a response, they just told me, well, this guy that I'm doing this for, in the response, that Muscat, this guy don't know what he's talking about because Muscat tried, he the one that informed the police that this informant probably was lying.
Yeah, that's actually, he directed the police to recruit the informant.
Yeah, and we got the documentation on this. We got the documentation, but Kim Worthy still allowing these people to put on paper that this didn't, what happened. But the documentation says it's his own damn memorandum.
Wow.
Where he's asking, matter of fact, you know who he asked? He sent the memorandum to Commander Tolbert.
James Tolbert. Yeah.
Yes, he's the one that's on the Brady list for lying in the Devontae Stanford case.
Mm-hmm.
So, I mean, come on now. This is just ridiculous.
Well, I want to thank you, Mr. Herndon and Diane, for coming on tonight. As usual, you bring out so much information. Breveteer, did you want to close with anything?
Well, you know what? I want to say thank you. Oh my goodness, the information that you retain and can just spit out and educate, and Diane, the work that you do. Oh my goodness, I appreciate you. I appreciate both of you. I want to give a shout out to Sandra McCare, who was with us this evening. I agree with you. Kim needs to fire herself. I don't know if she's going to do that. Somebody needs to. We need to. And I think, you know, for these next, you know, until we do have our election, we really need to hone in on our communities and our local elections, please. And thank you, everybody who's listening, because we need to really look at who is in office and what is the track record. When you hear these stories of a legacy of corruption that is in the police, not just from one person, but from the grandfather on down, we need to wake up and change that narrative. We're accepting a narrative that we control. And we are our own demise when we sit our behinds down and refuse to act or do anything. And refuse to look at what is happening in our communities with our loved ones. And if it's not happening directly to you, you can't tell me that you don't know anybody who this is happening to, who wrongful conviction is happening everywhere all the time. Everybody needs to play their part. They're making judgment call on an arrest. They're making a judgment call before the arrest. They've already convicted the person before they've even had a trial.
Mhm.
And I need us to wake up. I'm believing that this is the turnaround. So shout out today, Alicia Dyer, Sheriff out. I'm gonna call her Sheriff. Jay, let's call her Sheriff ahead of time. We're gonna
Right.
call her Sheriff in advance for Washtenaw County. And anybody else who you know is doing the work, who is standing for people who are wrongfully convicted, who really wants to turn things around, please, please get in touch with us so we can make sure and just get the information out to people. Share the name. Share the name so that people just aren't going to the polls and picking the person whose name is familiar or the
Yes.
name brand of politics.
Right.
I'll stop, Jay. But I thank you guys. Thank you so much.
Yes, and thank you. And Travis, I hope you'll join us again because you are a wealth of knowledge.
Yeah.
I don't know if some of your viewers will want me to come back because see, my thing is like I understand when you go start talking about these professional Negroes, they gonna say you're just trying to tear them down because they're a black man. You know, they use the same thing, Clarence Thomas. This is nothing but a high tech lynching. You know, you need to be hung, not by no white, but by your own people.
Right. Yes, I agree. Thank you so much. Thank you, everyone. We'll be back next week. We're going to be back with a case that you know about, Miss Diane, with Mr. Abdul Roosevelt's, I can't think of his last name.
Yeah, right.
Yeah, we'll be back with that. So if you guys want to join us, you're welcome. But thank you again. I appreciate
What
you.
case did she say, Dan?
Roosevelt's case. She's talking about Roosevelt's case.
Oh, okay.
He's quite familiar with that case.
Okay. Yeah, so we'll see you guys next week.
Okay.
Turning a moment into a movement. Thank you so much. Good
You're
night.
welcome. Thanks for having me.
Oh,
I
you're
know
welcome.
I might have been a little hard on professional Negroes, but hey.
You said it is what it is. Good
It
night,
is
everybody.
what it is.
All
Good
right.
night.
Good night.
Thank you. Thank you for having me.